so much has happened beyond the decisions in the Supreme Court, right? Coming
Yeah.
down from the Supreme Court. We've got Clarence Thomas taking $20 million in gifts, or excuse me, not 20, $4 million in gifts. $4 million, he wishes 20. $4 million in gifts. We've got the flag debacle between the Alitos now, flying the upside down American flag on their Virginia home, the appeal to heaven, stop the steal flag on their Long Island home. And then we've got these tapes, secretly recorded tapes, with the Alitos basically like agreeing with someone who poses as a Christian conservative.
Lauren Windsor, it's my girl, love her.
Lauren Windsor, and I have the tapes, but I don't want to take up too much time, but I wanted you to sort of weigh in on this broad, this has really been the year of the unmasking of this kind of corruption from the likes of Thomas and Alito. How much does this matter versus what they're actually ruling on? Give me your sense of this.
Yeah, you know what I think really matters about this unmasking for the conservative Supreme Court justices is that it really sort of breaks apart the myth that these are incredibly smart people. Right. They're just not. And that's what we've been saying on the podcast for 4 years on 5 to 4, that they're just not. And it's this mythos around the Supreme Court, that they do this sort of objective analysis, that these are the smartest, most accomplished, and rightfully the most powerful lawyers, judges in the country, right? That really shields the Supreme Court from a lot of, I think, very legitimate criticism. And so shit like this, these stories coming out, the corruption scandals, not just with Clarence Thomas, but with Alito too, and other conservative justices, really, really breaks apart at that sort of mythos, that ivory tower separation, that we must respect them and we must defer to them because they are, they're so intelligent, right? And they're just not. It turns out actually that they are Fox News watchers, OAN watchers, super, dyed in the wool Christian religious conservatives who are just as crazy as the people Walter is hanging out with, right? They're just as crazy as them. But the thing that you mostly hear from them publicly is, sort of disguised in legal jargon, right?
Yes.
So that's what I think is really important about these messages and that or these stories breaking, and that people put that in their context then when they are hearing about Supreme Court decisions.
Yeah. Now, I mean, my initial reaction is what's the pushback, right? We've known, obviously, thanks to Leonard Leo and, the Federalist Society, that these justices have been groomed for a long, long time to be where they are. That's all, they actually have a plan. Liberals do not have that same plan. And what is the plan now that it is so clear just how corrupt they are, and they're so allergic, or say they're allergic to ethics investigations or testifying before Congress? I mean, beyond the we know expand the court and we know actually term limits, but what's the pushback here? Are you seeing? Is it dawning on some liberals, some Democrats, some liberal think tanks? What is your sense of how much the veneer has truly fallen off, that these people are just stupid ideologues?
Yeah, I think the veneer has fell off, whatever. I think the veneer has been cracked, let's say, for the general public, right? To a degree that it hasn't in decades prior. I think the last couple of years on the court, maybe even since the Trump administration and Trump got his 3 nominees on the court, right? I think that veneer has cracked for the public, and the real deep problem is the same thing that you're saying, that actually liberals in power, liberals in our government, whether that's the Senate, whether that's the presidential administration, they aren't taking that veneer cracking seriously. And they're not taking the like wildly negative consequences that the Supreme Court sort of hands down on all of us. They're not taking that seriously. So like in this really sad way, you know, I'm thinking about bump stocks, because there was this recent Supreme Court ruling about bump stocks, semi-automatic
that was
weapons.
Trump's.
Yeah. Isn't that so wild? Isn't that so wild? Yes.
He banned it, and they were Trump was like not right wing enough for them.
Right. So that's what I was saying. Like that is kind of on my mind, and this sad thing that like I think a lot of people have started to say over the past like 5 to 10 years, right? Is that like if our society sort of already endures and does nothing about mass shootings in this way, then like it's not getting better anytime soon. And I think sadly that's also right about a Supreme Court that, for instance, will overturn Roe v. Wade, right?
Yeah.
If a Biden administration wasn't going to do anything about that, then I think sadly there isn't pushback that we can count on anytime soon.
Yeah. You know, one thing about the bump stocks that I didn't really understand until just recently was that this is to make a semi-automatic weapon fully automatic, a machine gun, i.e. the AR-15, which is already the leading gun in mass shootings, make that even more deadly. I mean, this is
the AR-15 was just
wasn't cutting it.
I mean, God.
Yeah. And this is a semi-automatic gun, which was outfitted with a bump stock, this like add-on accessory, right, is the weapon that was used, for example, in the Las Vegas shooting, which is like the deadliest, if not maybe the second deadliest mass shooting in the country. Injured 500 people, killed dozens. That is the weapon. And in fact, in response to that tragedy, that is when President Trump's ATF changed the rule, which somebody sued over, and now the Supreme Court, with an even more conservative supermajority than Donald Trump's ATF, said that rule, sort of classifying bump stocks as basically making a semi-automatic weapon into an automatic weapon, which is therefore illegal, turning that over, saying no. That rule, that doesn't work for us.
Well, that brings me to my question that I think applies to a lot of these cases, and we may not get a chance to go through all of them, but which is sort of the astroturfing of some of these plaintiffs here, that some of the lawsuits that are being brought are very much fabricated. This guy, Cargill, I guess is Michael Cargill, gun store owner in Texas, seems to maybe not be a plant, but I don't know. But this one guy's like, hey, I want to sell bump stocks in my store. You're denying me money. And then the Supreme Court's like, yes, bastion of free market entrepreneurship who wants to sell people ways to kill others faster. We must defend your rights. Without dallying too much on him, there are other cases like 303 Creative versus Elenis that basically allowed people to now discriminate once again over on the basis of, in this case, it was sexuality, but it could be applied to gender. How are these cases astroturfed by powerful interests? What does that mean?
Yeah, I think this is a really good question. And I just want to bring it also back to corruption, because the cases are astroturfed in two ways, right? Okay. Justice Thomas just basically disclosed that he's gotten at least, this is what he's disclosed, he's gotten at least $4 million worth of gifts in the past, let's say 20 years, right? While he's served on the Supreme Court. And Justice Thomas, for example, wrote the majority in that bump stock case that just came out a week or two ago, right? So that's one way you astroturf your cases. That's what $4 million buys you, right? Is somebody who is writing absolutely wild fringe theories into majority opinions, right? So that's one way things are astroturfed. And then the other thing is, it's really, really important. I'm really glad that you brought this up about the plaintiffs. You're right. I don't have any kind of specific information that the plaintiff in the bump stocks case was, sort of like picked and found and like brought up through the federal court system by one of these shady organizations. Although you can assume that they were involved somehow. But yeah, there's these organizations, the Alliance Defending Freedom. In affirmative action cases, it's this organization called Students for Fair Admissions.
Right.
All of these people that are, they call themselves like public interest legal organizations, and they work across the country, funded by dark money, to find these perfect plaintiffs. So 303 Creative is a really good example, because not only was that plaintiff the supposed web designer who made wedding websites, and then she actually didn't even make wedding websites.
She never made a website.
Right. So not only was she found by one of these organizations, and then they represented her, right, and took her case to the Supreme Court for the purpose of, this kind of ruling. That organization tried out similar cases with similar plaintiffs in other federal circuits.
Jesus.
Right. So they have, there is a master plan at work where there are, conservative, wealthy, moneyed interests paying for this kind of experimentation in federal courts, so that they find their perfect little case that makes its way to the Supreme Court, and then they've paid off the judges to rule in their favor.
The district in North Texas where like they love taking their cases.
Yeah.
It's like how they get the legal precedent. And it's like one of these counties where they're like, all right, we got to take it here, baby. Like, let's go.
Yeah. So the state of Texas, obviously, the state of Texas is always suing the Biden administration. And what Texas will do is file their cases. They do judge shopping, basically. They file their cases in federal districts in Texas where they basically have certainty that a certain federal judge will end up with that case, that it'll be assigned to that federal judge based on like how big that district is. Yeah, that's another way of astroturfing, of shopping the route to the Supreme Court, even if Texas isn't like choosing plaintiffs, just representing the state.
And this mifepristone ruling sort of exemplifies that, not because of I guess the role of Justice Ho in the Fifth Circuit, which is he was appointed by Donald Trump.
Uh-huh.
I've just been privy to this part of his ruling. This is Justice Ho. This is not the Supreme Court allowed mifepristone to not basically be banned nationally under the idea that like the FDA had like messed up when it approved this incredibly safe drug that it studied for 3 years.
Yep.
But make sense of this. Judge James Ho, this is Susan Rinkunis, tweeted a while ago, sworn in by Clarence Thomas and Harlan Crow's library in 2018, said anti-abortion doctors have stand in the abortion pill case because they like looking at babies.
Mm-hmm.
He cites, quote, aesthetic injury from cases involving wild animals and plants. And this is his writing. Quote, unborn babies are a source of profound joy for those who view them. Expectant parents eagerly share ultrasound photos with loved ones. Friends and family cheer at the sight of an unborn child. Doctors delight in working with their unborn patients and experience an aesthetic injury when they are aborted.
Mm-hmm.
This is the kind of extremism we are fucking talking about.
Yeah.
That guy, if Alito or if Trump is reelected and Alito or Thomas resigns, that's the kind of judge who could be appointed to the fucking Supreme Court. Someone who says, no, the problem with abortion is I don't get to see your baby bump.
Right. No, absolutely.
Well,
so
somebody think of the doctors. Somebody.
Yeah, exactly. And you know what is like so whatever about this, like so inducing of rage is like how inconsistent and hypocritical their own like standards will be applied, right? So standing doctrine, like what Judge Ho is saying that like gives these doctors, he's saying the doctors have standing, they have the ability to file this lawsuit because they're injured in this way, right? Standing doctrine actually is something that the conservative legal project has been restricting and restricting and restricting for decades because they don't want people to be able to sue, actually, right? They don't want people suing for their civil rights to be able to get into court. So tons of cases are thrown out by the Supreme Court. There are tons of cases by the Supreme Court, say in the last 40 years, written by conservative majorities that say like, oh, actually this plaintiff doesn't have standing. You don't have standing because of this. You don't have standing because of this. So bye-bye lawsuit, right? But here, it's so interesting that a super wildly conservative lower court judge is saying, oh no, like you can get into court with this with like the stupidest theory possible that like this make doctor sad so he has standing, right? Like
it's like, is there someone you forgot to ask? Like, yeah.
Right, exactly. So it's absolutely ridiculous. But then on the other side, you're right, Francesca, like, you know, according to standing doctrine, it's so wild that the Supreme Court did throw out that theory, that crazy theory of standing 9-0 unanimously. But, you know, I don't feel good about it, knowing that these judges, what they're doing with these rulings is auditioning for a next conservative president. Knowing, right, they're putting Kazmarek in the Northern District of Texas is one of them who has these wild opinions about mifepristone. That's where the mifepristone case started, right? Judge Ho on the Fifth Circuit Court of Appeals. These judges in these wild opinions are auditioning and showing off their ultra conservative chops so that a future Republican president already knows, and a Federalist Society that is handing that future Republican president the list of Supreme Court nominees, they already know who's in line, right? It's fucked up. It's super fucked up.
I have three more things, but I did like, I guess maybe because I'm afraid we won't get to it, I do want to talk about like presidential immunity and the Jan 6 fallout, because it does seem like the Supreme Court has now two cases in front of it. One is, can the president do whatever president want to do, crime included, and also whether or not those rioters who stormed the Capitol who could actually have.
They were there on a tour. Yeah, it was just a peaceful tour. You know,
could they upend? I
mean, how many people normally die on tours of the Capitol?
I mean, if it was a good tour, at least 5.
The CDC doesn't report it.
Fauci fudged those numbers, you know?
Yeah, like they hide it. All the deaths that happen on normal, peaceful tours of the Capitol. You know?
So I think these are consequential, but they may be punted. I don't know. Can you give us your take?
Yeah, I mean, you know, let's take just like the Trump immunity question really quick. Yeah, the question in front of the court is like basic. I mean, what Trump's side is arguing is that like you cannot hold a president liable for any crime, criminal, civil, you know, whatever, for something they've done while they're in office. It is a radical sort of unprecedented argument. I don't think, even if the Supreme Court was, you know, decided that case tomorrow, I don't think the Supreme Court would fully agree with Trump's argument. But what they're doing instead is like completely abdicating that responsibility, and they're punting, right? So they scheduled the case to be set for oral argument at a very late time, which basically ensures that they won't have a decision, whatever their decision is, before the election. Right. Which is what would actually, which is what in the short term, like really matters. Like, can Trump be prosecuted? Can there be lawsuits filed against him for the things that he did as president? And that would affect the election, obviously, right? Whether or not he's on the ballot, maybe in some states, et cetera, et cetera, et cetera. Whether the public knows if, you know, if the president is, you know, being accused of certain crimes or held accountable for certain things, right? It in the short term, it really would affect the election, and the Supreme Court is saying like it'll be sometime after that.
And that is therefore delaying these other cases, whether it's the Jan 6, you know, case about inciting a riot, or the classified documents case. Is that correct, that they're sort of punts both of those?
Yeah. I mean, these things are being punted, and like the end result is that like we could be in a Trump presidency already
Yeah.
when these decisions are handed down. And so it's like,
no need to hand him down then. But it'd be very
Right.
funny if they gave Biden presidential immunity and he wouldn't know what to do with it.
no.
The
he
best
wouldn't.
part about the immunity part is that Trump wants immunity for things. These are things he did before and after he was president. He's like, because you could actually have a real conversation, be like, well, to run the country, you need discretionary powers, and
Sure.
and that's actually a real conversation. So what did he actually do during that he's getting prosecuted for? Is the insurrection,
right?
Yeah, like trying to throw out votes in black people's votes, and trying to overthrow a democratic election. The rest is he wasn't even president.
Right. The rest, I love the precedent that the rest would set, that if it was like, well, actually, your proclivity to do crimes, including financial crimes and all kinds of, stealing really shows just how presidential you might be one day.
Right.
Like,
exactly.
This guy
is a good resume.
Yeah. You could pardon yourself in a heartbeat. Okay, before you go, any final? I wanted to ask you a little about the union stuff. I found that the ruling around was it Starbucks v. Tennessee or I don't know what the name of the case was, but basically ruling that it was okay for a Starbucks franchise to fire 7 workers in Memphis who tried to unionize. And it's sort of it seems like a proxy war between Supreme Court and the National Labor Relations Board, which was trying to hold Starbucks accountable for that retaliation. But can you explain how chilling this is and why the Supreme Court wants to take these cases up?
Yeah. Okay. So I'll say this is a blow. It's a blow to sort of the NLRB, the National Labor Relations Board. It's a blow to sort of labor, let's say, organizing and labor law.
Mm-hmm.
But I'll also say that it's not a huge blow, because actually what this case was about was it's like getting into the legal weeds, but it was about the standard by which a court would grant an injunction to the NLRB. So what the NLRB was trying to do is say, no, we want to enjoin Starbucks from firing these people. Starbucks, you have to rehire them while the case plays out, right?
Mm-hmm.
So like pending appeal, these people should have their jobs back. And
I see.
The fight legally was about when can a court give the NLRB that kind of injunction? Now, there was we call it a circuit split. Like some federal circuits were using the harder standard, and just a few were using the easy standard that NLRB wanted, so that they could more easily get injunctions like this. So the actual legal effect, it actually is not that big, because most of the country wasn't even using the standard already that the NLRB wanted. But you are right that it is in a long line of cases, right, where the Supreme Court is attacking not just the NLRB and restricting their power, but the administrative state in general, right? So federal agencies like the EPA, for example, like the ATF, all of a sudden,
Right? Yeah.
All kinds of stuff like that. So,
and that has to do with the Chevron doctrine. Is that what's the Chevron thing? And lastly, last, because you got to go.
Yeah. There is sort of like a rule that courts have adhered to for a long time called the Chevron doctrine, which basically says that judges, when deciding cases about what federal agencies can do, administrative agencies, that they kind of defer to the expertise of the agency, right? So take for
people
example,
who studied these things.
Yes, for example, last year, there was an EPA case about what is a river? What is an aquifer, right? The Chevron doctrine would say judges should defer to the EPA.
It's like the Matt Walsh. It's like the Matt Walsh of the environment.
Right. Yeah. What is a contiguous body of water, right? Chevron would say judges should defer to what the EPA says about that. They're the experts on that, right? And so the Roberts Court definitely wants to get rid of Chevron doctrine, that kind of general approach to cases, because they want to be able to slap the hand of any administrative agency and say, no, you don't have the power to do that. No, you don't have the power to do that.
It is the Matt Walshes of Congress who can say what a river is.
How come you 100%. Can't tell me what a river is?
Right. No, it's Sam Alito. It's Sam Alito who should be able to say what a river is, right? That's what they're going
So
for.
it wouldn't necessarily, it would fall to the courts to be able to rule it. That seems like a lot of extra work rather than legislators. Like, I'm just wondering, they're basically like, no, we're taking the power out of, you're basically defanging the administrative state to do any kind of enforcement or regulation.
Yeah, that's exactly right. And the administrative state is given power by Congress, right? Like Congress created the EPA and then gives it all the powers to do that work so that Congress, right? Congress says, y'all are the expert body. Like Congress doesn't necessarily come up with the definition of an aquifer, right? Congress gives it power. So while the Supreme Court is like chipping away at the power of the administrative state, it's also a blow to congressional decisions, right? That deferred and gave power to these administrative agencies. And so, yeah, you can look back at that EPA case. It is absolutely Sam Alito in the majority defining what a contiguous body of water is, right?
Oh my God.
So it's just saying like, we're the experts.
Let the states decide. Just
Yeah.
let the states decide. Let
right.
all 50 states
Uh-huh.
have their own individual interpretations of a contiguous body of water.
Right.
That doesn't sound like a bureaucratic nightmare at all. Just like, Iowa, they get to.
It's just amazing that you would like, let Congress, let like lawmakers, notorious for being, very efficient and expediting all kinds of decisions. Let them decide. What's going on, Frantifa? If you haven't already, subscribe to this channel right now. Hit that button. And also, you can become a patron and support the show every single week. Get access to bonus episodes and exclusive merchandise. Patreon.com/Bitchuation Room. Do it.